Before this hearing even begins, tensions are already high. In this case, Mr. Henry is facing a detention request from the state. But what should have been a routine procedural step quickly turns into a tense courtroom moment. The defendant desperately wants to speak, insisting he understands the charges and believes the system is treating him unfairly. Meanwhile, the judge and attorneys are focused on one thing: following strict legal procedure. What unfolds next is a dramatic clash between frustration and courtroom rules. Did the judge follow the law correctly? Or did Mr. Henry deserve a chance to be heard? Let's break down what happened.
All right, this is the matter of State versus Henry. It's under warrant W-2026-95-0814. Counsel, your appearances for the record, please.
Your Honor, Jacqueline Caban on behalf of the state.
Second, Donnarumma on behalf of Mr. Henry.
Thank you. So the state's filing a motion seeking to detain Mr. Henry. Is the state prepared to proceed with that motion today?
Your Honor, that's going to be a state request for a postponement. I initially was asking for 3 days, but I think that I received some of the information I was looking for. So I'm just going to ask the 2-day postponement.
Ms. Donnarumma, anything you'd like to add before I explain what's going to happen?
No, I appreciate Ms. Caban getting us the discovery as quickly as possible. And Mr. Henry, I will be your lawyer on Monday and argue for you to be released then.
Can I speak to you, please, Your Honor? I meant my lawyer, please, in the break room, please.
Sir, today I do not have the ability to speak to you. We did.
Your Honor, can I please say one thing? I'm sorry. No. I'm so sorry.
Just hang on then. Okay. Let me just give. Don't cut me off. Let me say a few things. Anything.
Right here, we start seeing the tension build. Mr. Henry clearly wants to explain his situation immediately, but the judge is stepping in to slow things down. In criminal court, anything a defendant says on the record can later be used against them, which is why attorneys often warn clients not to speak freely in open court. The judge is actually reminding him of this risk. At the same time, from Mr. Henry's perspective, he feels like his chance to defend himself is being taken away. This moment highlights one of the biggest frustrations defendants face in court. The system prioritizes procedure and preparation over emotional explanations. But what do you think? If you were in Mr. Henry's position, would you stay silent like your lawyer advises, or insist on telling your side immediately?
That you say right now is not going to change what's happening, because the state has the right to do it, and they have to do it because they didn't have discovery. Now, I'm going to represent you in 2 days, and I want to hear what you want to say, but I don't want you to say it here in front of everybody. It's not good.
Your Honor, can I please say something, please? I mean, lawyer, please. Monday.
But now, I'll give you an opportunity if you still want to say something. But let me say something first.
I just feel like I know my charges and I know what's going on. But when I went to court on Monday, they detained me for 3 days. They said they detained me for 3 days because of the prosecution suggested 3 days for my remandment, and they told me to come back Thursday for my disorderly persons and the TRO.
Yeah,
I
understand all of that. I do understand all of that. But let me explain to you what has to happen. There's a law, there's a statute that governs these proceedings, these detention hearings. And that law gives both sides the opportunity to ask for an adjournment. The state has an opportunity, the defense has an opportunity to ask for an adjournment so they can get more information, which is exactly what happened here. The state collected information, they need to give that to your attorney so she can look at it and she can talk about it with you. And that way I get everything about the case.
Okay, Your Honor, fine, that's cool.
But let me say one more thing, sir. I'm sorry to interrupt you, but let me just say one more thing. I understand that you were here 3 days ago. That was your first appearance. At that point, the state filed a motion to detain you. That happens 3 days later, which is today. This would be the motion for today. That law gives both sides an opportunity to adjourn from today, and so they can get the information that they need for the hearing. So there's nothing wrong with what's happening. It's all according to the law. And frankly, there's absolutely nothing your attorney could say or do that can take that right away. There's nothing I can say or do that can take that right away. And understand, sir, and I'm just going to repeat what your attorney said, then I'll just talk if you want to. Anything you're saying here, it's all being recorded. And anything you say can be used against you later on. If your attorney talks, that can't be used against you, but anything you say can. So just be aware of that before you speak. So is there something?
Okay, Your Honor, can I please talk to my lawyer in the break room, please, for 1 second?
Sir, no, I have a list today. Call me. That's what I was trying to tell you
can't,
earlier,
Your
but you
Honor.
kept cutting me off. Not Your Honor, Rebecca. I'm speaking.
I'm sorry, Miss Rebecca. I'm so
So just
sorry.
listen for a second. Ask the social worker. His name is John DeSant. To give you a call, to allow you to call your lawyer, Rebecca, in the Gloucester office. He knows me very well. You have a right to it. Do it between now and Monday. We can talk.
I can't call on weekends, sir. I'm already missing work. I just got hired.
Today's Thursday. We have all day tomorrow. Call me.
My restraining order got dismissed.
Yes, sir.
Attorney, I just want to speak to who can help me, please.
It's me. It's me, and I'm telling you, I'm giving you instructions on how.
I understand, Miss Rebecca.
Okay.
I understand.
So call me tomorrow.
I don't even know the circumstances of my charges and why I have to be
If you call me tomorrow, I can tell you all of that.
At least prosecutor, can you please postpone till tomorrow, please? So, please, because I'm going through a lot right now. I just had a job that I was supposed to be on Monday, starting my night shift, and then hopefully I can still get into my job.
Your Honor, may I request that we mute my client? I do not want him to say any more on the
Well, at this point, Mr. Henry, there's absolutely nothing more to talk about. I'm postponing the matter pursuant to the state's request for next Monday. That's when it's going to be heard. That's the end.
So what happened with today, Your Honor?
This is the moment where the emotional reality of the situation really hits. Mr. Henry isn't just arguing about legal procedure anymore. He's worried about his life outside the courtroom. He mentions missing work and potentially losing a job opportunity. For many defendants, even a few extra days in custody can have serious consequences for employment, housing, and family responsibilities. But from the court's point of view, the priority is making sure the detention hearing is done properly, with both sides fully prepared. Notice something else important here. His own attorney asks the judge to mute him. That may sound harsh, but it's actually a defensive move to prevent him from saying something that could damage his case later. Still, moments like this raise a big question. Is the legal system protecting defendants from themselves, or does it sometimes make them feel powerless in their own case?
You're going to be detained until Monday when the matter can be heard.
Why Monday? I thought it was going to be heard on Thursday. Why do I have to wait an additional 5 days?
Sir, the whole point of this hearing is to determine whether you should be released or not. There's a possibility that you're not released at all. That's the whole point of these hearings. That's why you want to have your attorney know everything about the case so she can better prepare. You can talk to her, but you can't do it today because my list is very big and she doesn't have time to do that. But you can call her tomorrow and she will speak to you.
But that's why they told me on Monday that Thursday was the day that I can go over with my public defender the case.
Shut up! Shut up! Shut up!
I didn't even, that's what I thought.
I'm telling you right now it's going to have to be tomorrow.
Huh?
I'm telling you right now it's going to have to be tomorrow because she's busy. She's got to deal with other cases that are in front of her.
Okay, I respect that. Can we postpone the matter till tomorrow and I'll give my lawyer a call today?
The answer is no, sir. It's being postponed until Monday.
Prosecutor, can you please
Mr. Henry,
for today?
Mr. Henry, I'm stopping the matter right now. You can be excused from the booth.
There's no way I'll be sitting here, sir. I'm going through things, bro. It's not fair. I didn't even get a chance to talk and be detained.
Mr. Henry, please leave the booth. You're going to get a contempt order or a touch order to pull you out. Just leave on your own accord and call me tomorrow.
Your Honor, that means I gotta stay for the weekend, Your Honor. Y'all releasing people with gun charges and shit. I'm innocent.
Really?
I'm innocent. I didn't touch nobody. The TRO is dismissed.
May I request that we mute the booth because I don't want him to continue speaking and I'm not in person to be able to have better client control or to whisper.
How can I tell you?
Mr. Henry, I have no problem
Thank
muting
you so much.
Mr. Henry, I'm asking you again. I can't hear what you're saying. Please excuse yourself from the booth.
Don't escalate it, Mr. Henry. No one can hear you. You're muted. Just leave the booth and call me tomorrow. Don't escalate this situation. Don't make it worse.
Mr. Henry, you're muted. We can't hear a word you're saying. The is filed at this point. You need to leave the booth, please, sir.
This hearing shows just how intense the courtroom environment can become when legal procedure collides with human frustration. Mr. Henry believed he was being treated unfairly and desperately wanted to speak and explain his situation. But the judge emphasized that the delay was lawful, a procedural postponement designed to allow both the prosecution and defense to review evidence before deciding whether Henry should be released or remain detained. Ultimately, the case was postponed until Monday, leaving Mr. Henry in custody over the weekend. Situations like this remind us that in the legal system, process and preparation often take priority over immediate answers. But now we want to hear from you. Do you think the judge handled this situation correctly? Or should Mr. Henry have been given more opportunity to speak? If you found this courtroom moment as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more shocking courtroom breakdowns and real legal drama.